Hi, everyone. We'll just let everyone in the room and then we'll get started. It'll just take a couple of minutes to get everyone here. All right. It looks like everyone's in now. So, welcome everyone on behalf of the Law Society of Nunavut. And thank you particularly to Anne-Marie McElroy, who's going to do a presentation on client management. You may know her from such podcasts as the Solo Queens podcast, and she is a really great resource about practice management, client management, and also criminal law. And I'm really grateful that you were willing to talk to our bar in Nunavut about some client management strategies. So thank you again. And for the folks in attendance, if you routinely attend our Lunch and Learn series with the Lost Side of Nunavut, then you will know that we have other workshops coming up on a variety of different topics, and they are all free of charge, and the recordings are posted on our website after the fact. So Anne-Marie, also as a heads up, we all speakers are unpaid, but there will be swag. So look
Oh,
forward to some sort
okay.
of artistic, memory of the fact that you so generously provided your time. So thank you
Awesome.
again, and
Okay,
I will let you run with it.
perfect. Okay, well, thanks so much, Rebecca, and thanks for inviting me to be here. So I am very pleased to present today on client management. So we'll just kind of dive in. This is sort of my background. So I'm a criminal defense lawyer in Ottawa. I've been practicing for 14 years now. I worked as in a firm to start with, but then have been a sole practitioner for about 5, 6 years, and now have one associate. I've also taught at the University of Ottawa and have did a pretty fun project with a good friend of mine called Solo Queens, where we did a bunch of workshops helping young solo defense lawyers to kind of navigate the business and practice management side of things in law. And I'm also working on a book that is of the same sort of stuff, the same sort of content. So I'm going to cover a bunch of different things. I'm quite happy if people have questions throughout. If you want to speak up, that's totally fine with me, but we'll also leave some time at the end for questions. So just to kind of clarify, I'm coming at this topic from a criminal defense perspective. I don't know sort of what the lay of the land is with everyone else who's watching this today. But I think a lot of the sort of the principles and the ideas will translate into different areas of law, whether it's you're doing family or real estate or civil matters. It all kind of comes down to the same stuff. So here's what we're going to go through today. So the first bit is just kind of I'll talk a bit about the solicitor-client relationship and why it's such an important thing. We'll talk about setting expectations and boundaries, and also recognizing and dealing with different client needs and how to sort of flag those and be aware of them. Talk about money and getting paid, which is always very important. To manage how to manage difficult relationships, and again, these are like way big topics that are way too big for one hour lunch and learn, but just kind of things to turn your mind to. And also about ending a relationship, and sort of what are some best practices in terms of ending a solicitor client relationship. All right. So a solicitor client relationship is it's something quite unique, right? It's different than a familial or a friend relationship, and there's a few different reasons for that. One of the main ones is that it's guarded by solicitor client privilege, obviously. So that means that you're not able to speak about what is discussed with your client outside of that relationship, with certain narrow exceptions for the court, things like that. There's also a bit of a difference in terms of the expertise that a lawyer brings. And so there's a certain responsibility to be educating and informing the client about their case and what their options are, and allowing them to make an informed decision going forward. Okay. And again, the main duty that the lawyer has is to their client, right? Like everything that we need to do is in service of that client and in their best interests. And they sometimes they don't make it easy on us, but that's okay. There's also that has to be balanced with a duty to the court, right? So we do have certain duties that we need to show up for with the court. And all this to say is that how we manage our relationships with our clients really speak to how our legal work is going to end up. And so, if you have a better solicitor-client relationship, better management of your clients, then you're going to end up with better outcomes for your clients, I believe, and that in turn will lead to better business for yourself. Okay, so obviously everything that we are talking about and everything that a lawyer does exists within the framework of the Law Society obligations. And this is like boring and not interesting. However, it's really important that in all aspects of practice, that we're remembering that these are sort of the guidelines that we're working within, okay, in these frameworks. So within the code of conduct for Nunavut, there is a duty to provide courteous, thorough, and prompt service that is competent. Sorry, I'm moving this timely, conscientious, diligent. And one of the subheadings there in terms of the discussion is that there's a duty to communicate effectively with the client. And so that's like a pretty broad thing to say to communicate effectively. But it means that it starts from day one of when you're first doing an intake with a client, that you are laying out sort of what they can expect, what the process is going to look like. And so you need to be mindful of how you're communicating with the client. Again, not only for that relationship and for better business and stuff like that, but also because you do have an obligation to the Law Society. Okay, and we kind of touched on this briefly a moment ago, but obviously the starting point is that there is that solicitor-client privilege and that a lawyer has to hold in confidence all the information that they're acquiring from their client. And there's some narrow exceptions to that. But this is one of the really foundational building blocks of the solicitor-client relationship, is that the client has to feel that they are free to share whatever they want with the lawyer, and so that there's that sort of free flow of information that is sort of allows for that level of trust. Okay, and I'll talk about this a bit later on, that like, you know, the lawyer has to be the one that sort of controls the flow of that information a little bit to make sure that they're acting in the client's best interest. But again, these are sort of the building blocks or the frameworks that we're starting with. Okay, so I think really one of the key things about managing clients is setting the expectations from day one. And I think when I started out, I was just so like a little bit overwhelmed at all of a sudden having clients of my own. And I wish somebody had sat down with me and said like, okay, how this relationship goes and how well it sort of develops and how well you can manage conflict within the relationship starts on like absolutely day one. Okay, and it's really important that you are setting out from day one what the expectations are. And so that means both for the client and for the lawyer. So the client needs to know like what are things that are going to happen sort of procedurally, what they can expect and what's being expected of them. Okay, and then so we'll talk about this a little bit more as we go on, but they happen sort of within a few different times. So again, starting in day one from your intake, okay, when you're first meeting with the client and deciding whether or not they're going to become a paid client, through a retainer agreement, and I'm going to go on a bit at length about retainer agreements, and then they can also be brought up throughout the relationship. Okay, so the first step that we usually have in a solicitor-client relationship or in any file is the intake. Okay, so this is the time that you're sitting down with somebody who might wander into your office looking for legal representation, and this is the time to make the first impression on the client and to start to build that relationship. So the first thing that we need to keep in mind with these intakes is that it's a really good opportunity to build rapport with the client. So a lot of time we can think about like the intakes as just kind of taking down rote information, sort of the ID and date of birth and all this kind of stuff. But it's a chance to sort of get to know the client a little bit and to start to build that relationship. So it's good to spend some time to sort of expand a little bit beyond just sort of whatever is on your intake form or checklist that you have, to ask them a little bit about their family, about where they work and other things like that in order to better build that relationship. Along with receiving information, you're going to be providing information to the client. So in my line of work, clients may be being charged with a criminal offense for the first time in their lives, and they're super scared. They don't know what to expect. So I spend some time in that first meeting sort of laying out, like, here are the steps in a file usually. So this is what a first appearance in court means. This is what disclosure means. And so I'm able to provide them with some information about what's going on to hopefully put their mind at ease a little bit so that they're feeling a little bit better about what's going on. And it's also establishing to them, or hopefully showing that I have some expertise in what's going on and that I'm going to be able to take care of this, and that is going to hopefully lower their stress a little bit. So along with that information, we need to educate the client about certain things. And these could be substantive as well as procedural. And so one of the things that, I might tell them is, I don't want to hear right this second about what happened or didn't happen that day. I need to look at the disclosure from the Crown first before we can have those discussions. So I'm providing information and education to the client about how things are going to work in order to better advocate for them at the end of the day. Having boundaries is also really important. And I've seen in Ottawa, where I'm based, I've seen a lot of young lawyers leaving private practice, partially because there's a difficulty in sort of keeping boundaries with their clients. And I think that criminal law clients can maybe be a little bit more needy for a lot of reasons. Things are high stakes. But it's important from day one to sort of establish, like, this is what I'm here for, and this is what I'm doing, and this is not what I'm doing. And also, this is when I am doing it. So, clients may think that you're accessible at all hours of the day. And for some people, maybe that's okay. Maybe you don't mind fielding a call at 8 p.m. I don't like doing that. And so, I try to be clear about, like, when are office hours, when I will be available, and even just to say, I have a busy trial schedule. So it sometimes might take me a day to get back to you. And if you can establish that from day one, then that helps them to sort of manage what they are expecting in terms of their the services that they're receiving. Okay. In all of this, there's a lot of different clients that we may come across, and so you need to be aware that there's different competencies that are going to be required for different clients, right? So how one goes about a meeting with an Indigenous or a racialized client, or their whole file, might be different than by someone who's not racialized. And so you want to have that sort of in mind. There are a lot of other things that we can keep in mind in terms of different competencies. Trauma-informed practice, again, it might depend a little bit from practice area to practice area. If somebody's in a real estate practice, it may be less at the forefront, but it's always important to sort of look at where the client is coming from and be able to speak to them, communicate in a way that is going to be mindful of their background. So same thing with mental health and addictions, or with people who are dealing with issues cognitively, whether it's due to FASD or learning disabilities. We're seeing a ton more people dealing with traumatic brain injuries, which can affect sort of their ability to recall certain things, memory, and so on. So it's good to sort of just be aware of these things, and there are likely some other sort of continuing professional development that can hone in a little bit more specifically on these sorts of things. But it's just something that I wanted to flag at this point. Okay, retainer agreements. This is also something that I wish that when I started, somebody had like hammered home to me that like a retainer agreement is a huge asset in terms of how you manage your practice, okay, and how you manage your clients. So I would go so far to argue is that in some ways, the retainer agreement is the foundation of the relationship. This is a contract that lays out sort of a lot of things in it. So it can lay out what the fees are, what the expectations are in terms of work, and then also address the ending of the relationship. And so sometimes it can be really, really helpful if there's a conflict about something, or not, by conflict, I mean just sort of a disagreement. To have this document to come back to is really, really helpful. So we'll talk a little bit more about this. So, okay, bless you. So a retainer agreement can be anything that you want it to be, and it's going to change from different practice areas. But what it really does is that it kind of solidifies what the parameters are of the relationship. So with me, what I do is that I have a template that I use, and I put the client's name at the top and my name and say, this is an agreement between us for this specific matter. So we are delineating that you are hiring me to deal with whatever, your assault charge in wherever. And then that's the scope of the relationship. So that if this person gets another charge, or if they have another legal issue that's outside of criminal law or my expertise, that they know that like that's outside of this. This is just for this. So I'm gonna have to figure that out if something else comes up. The last thing that you want is for the client to think that just because they've retained you on one matter, that they now have like a free-for-all in terms of your time and your services. And I have a friend who always says that, your legal aid certificate or warrior retainer, it's not a swipe card. It's not a health card that means that you can just get as much legal representation as you want. It deals with this one charge or this one matter, and then anything outside of that has to be dealt with. It can also spell out what the expectations are for the client. So this again is going to depend on the type of practice that you have and what kind of files you're taking on. So it could deal with the forms of communication, updates with respect to your file, when they will receive them and how. What are you expecting of them? Like in terms of if they have to give you documents or other information, what are the timelines that you need to hear back from? And so that's, again, it's going to depend on the type of file, the type of client that you have. But I find that that's really good to go through at the initial stages so that everyone is clear on what's being expected. My clients, some of them are really, dedicated to making sure that everything works out. I have others that are a little bit less capable of, keeping in good contact or of keeping the same phone number, things like that. So I want to spell it out at the beginning to say, I am expecting that you're going to stay in touch with me. If you lose your phone or you change your phone number, I need you to still be able to reach out with me to tell me what your new contact information is. And that's one of the expectations there. And then that's going to help me down the line if the client ghosts me, that I can say, listen, like this was the expectation and you didn't meet it. And so this is, I can't represent you for that reason. I mean, it's likely that I might not end the retainer because they just they weren't in touch for a little while, but it's good to have that there. Okay. Having the fees specified is really helpful. The last thing that you want is to have quoted somebody a fee in person or over the phone, and then they have a different expectation of what it is, you know, and whether or not that's because you've like haven't added the tax ahead, or you haven't or it sort of included the tax in it, or that they've just sort of understood something different. It's really helpful not only to manage the expectations of the client so that they know what is going to be there, but also so that if there's any disagreement down the line, you can just bring it up and say, you know, listen, this is what I quoted you, and this is what you agreed to pay. And so I would also include that if you're going to be doing any sort of payment plan with a client, that you put that in writing too, and that if possible, you include it in the retainer agreement, and then it's easy to look at again. You also want to address ending the relationship, so you can let the client know at the outset, these are the reasons in which I can end the relationship. And they're narrow, right? There's not very many. But if you fail to pay your retainer, if you ask me to do something unethical, if you're dishonest with me, that kind of thing, then that's a red line that I can't represent you anymore. And then you can also set out how the client is able to end the relationship with you, which really is often just anytime they want, as long as they provide you notice in writing. And so that's just also good to have laid out so that the client knows what to expect. Okay, in terms of money, this is something that I think for young counsel is hard to talk about sometimes. It's not something that we're trained to do in law school, and so it can be something that's difficult. But the more upfront you are about it, the better it is. And it takes time and a little bit of practice, but the more just sort of like straightforward that you can be with, this is how much money I'm going to need, this is how it's going to be paid out, the better it's going to be. Everyone's going to have their own approach to this, but in my experience, when you are firm with a client about what the fees are, then you can, it works better to establish that trust. I remember a senior lawyer telling me early on, like, don't negotiate your fees with the client, to a large extent, because if you're negotiating with other people, how is that going to help if they see that they've been able to negotiate you down, and then you're going to go into another negotiation with someone else about their file? So I think it's best to remain firm and then make sure that you are being transparent and fair, and then also again, if it's not included in the initial retainer agreement, then make sure that you have a written record to go back to as to what the fees are. And it happens sometimes that the initial retainer will quote a certain amount, and then there are additional fees that are required. And so even if you discuss those in person, I would recommend following it up with a letter or an email that tells the client, further to our discussion, I'm writing to confirm that, for the next chunk of work, I will need X amount of dollars in trust. And then that will help just in case there's any confusion down the line. Okay, so we've talked about sort of establishing the relationship at the beginning and the main times that you're going to do that, which are through the intake and the retainer agreement. Again, you want to have this open communication with your client, where you want the client to feel comfortable, to be able to share information with you. And you also want to be establishing sort of a good line of communication that, and I'm repeating myself a little bit here, but the expectations is what it really comes down to. So the client should know, like, when are they going to expect to hear from you, what they should expect to hear from you about. So in my line of work, I will tell them, I'm going to be in touch after this court date to let you know the outcome. There are some court dates that are not really substantive, that they may not need to know when the next date is. So I would tell them then, I'm going to be in touch with you once I get these documents, and then we will set up a meeting to review them. And so having that expectation will help them to sort of manage whatever stress that they're dealing with going through this file, and to be more responsive. You also want to establish the tone of the communication too. So that means that you're making the communication professional, And it can be a little bit more casual with certain clients if that's something that you're comfortable with. But you want to make sure that it's sort of staying within that professional framework and that it's not sort of, veering to be, too familiar. Because you want your client to feel comfortable with you, but this is still a professional relationship and you want to make sure that is sort of maintained. And the communication is really a good way of building trust. It's sort of hard to explain that anymore, but really, like, throughout your meetings and your correspondence, the client should know that, you're diligent, you're doing the work, you're fulfilling all of those things that are required that we talked about in terms of the Law Society obligations. Okay? Okay, so I think that for a lot of people, the clients are in some ways the best part of the job, and sometimes they can be a really difficult part of the job. Okay, so there's lots of times where the client may think that they know best, or that they've read something on the internet that tells them that things should be going a different way, or they're not listening to your advice or being open to reasonable resolutions. So there's lots of things that we can do in these sorts of situations to kind of help to smooth things out, and to maintain that solicitor-client relationship as a positive one. So a lot of it, unfortunately, comes back to sort of like what the intake and the initial conversations were. So establishing throughout those conversations, like, what's going to be expected, and what's reasonable, right? So it happens for sure, and I'm thinking to some examples within my own practice where, what the client wants and what they think should happen are really different from the reality of what can happen. Okay, so with that, there needs to be a really frank conversation there to sort of explain to the client that, like, that's not actually what's on the table there. So I apologize that the only examples that I can think of are within the criminal sphere, so it may not be relevant to some of you, but I think that it has some relevance to other areas of law. So just as an example, sometimes I'll be dealing with a file where the client has told me that they would like to resolve it. They want to plead guilty, but they want to end up without a criminal record. And it might be the kind of file where a criminal record is really, or a sentence that involves a criminal record is really the only one that's within a reasonable range. And so we have to have these hard conversations where you sit down and you say, listen, and you want to validate the client and their issues or sort of their stresses or fears, to say, like, I understand that this is something that's really important to you and that you feel that what happened is not fair. Here's what is on the table. Here are what our options are. Because at the end of the day, you're taking instructions from your client, and so they are the ones that need to decide. So if they are telling you, I want you to plead guilty, or I want to plead guilty, but I want you to ask for, something that's wildly outside of the range, there is a point that you need to maintain that professional, expert perspective and tell them, like, that's not something that I can do. And so again, there's that boundary there where you can't take instructions that aren't reasonable. And so there needs to be a discussion to sort of establish what the boundary is. And sometimes it may end up that if they are, like, insisting upon that thing, that it may terminate the solicitor-client relationship. And so you may want to think about what are some scenarios that would be sort of a deal breaker for you in your practice, and maybe that's something that you put into the retainer agreement as to the reasons that you might not be able to represent somebody. So if the reason, if the instructions aren't reasonable, might be something that could be listed in the reasons that you would be getting off the record for somebody. Okay, and so every situation is going to be different. I think that a lot of the time when clients are upset about their file, a lot of it is because they aren't understanding something that's going on, or they are something is unexpected that is leading to them being stressed about things. So you really need to take the time, if you can, to sort of explain the rationale behind things, and and then sort of draw what the line in the sand is. So another example of that kind of comes up sometimes in my line of work is that the client may have told me something that sort of bars me from calling them at a trial, or their version of events might actually incriminate them. And so if they're asking, for me to advance a certain defense that is not in fact a defense, and they're not listening to my advice that this defense is not going to be viable, then you may have to have that conversation about whether or not this can actually go ahead like that. So to say, like, listen, this is the way that I'm going to run the trial. I'm the one that chooses these strategic things. And, if you don't agree with that, then you may need to find a different lawyer for that. And so that's another thing too that you can think about in sort of the earlier parts of the conversations with the client, is sort of what things are going to be solely within their jurisdiction to decide, and what things are going to be sort of tactical or strategic things that you as a lawyer are going to be able to decide. Because if you're running a trial for a client, there's going to be a million little tactical decisions, but there are some main foundational ones that they are going to choose. So in the criminal context, they often come down to choosing their election, whether they're going to a provincial or superior court, whether they're pleading guilty or not guilty, and whether they're testifying at trial. So, being upfront about what their options are can be really helpful. And so, and taking the time to sort of make sure that you're fostering that relationship and that communication throughout these sort of tough conversations will sort of help to get you through. Okay, so again, we're going to come back to what the law society obligations are here. And so again, the obligation with these communications is that you have to be honest and candid with the client, and you have to inform them of all the information that might affect them. Okay, so that means that even if there's stuff that you would rather not discuss with the client, you have to be as forthcoming and upfront with them as possible. And at the end of the day, that's going to help with that relationship. And then this comes back to sort of the reasonable resolution part, that you actually have an obligation to encourage a client to settle or compromise if it's reasonable. And so that's something else to keep in mind when you're having these discussions. Okay, so ending a relationship with a client can happen in a lot of different ways, right? And some of them are ideal, right? Like if you close a case and there's a great outcome for the client, that's one thing. But it also can happen that you are fired, or you may fire the client. Okay, so with respect to firing a client, hopefully this isn't something that will happen too much to people throughout their career, but it may happen that there's just sort of like a breakdown in the solicitor-client relationship to the point that you can no longer appear or represent the client. So if this comes up, then you need to, again, be as upfront as you can with the client as to what has happened and the fact that you can no longer represent them. You want to be as clear as possible with them, and to have this in writing as well. And so, and we'll talk about this in another minute. Again, these conversations are not easy, but you do the best that you can to maintain a professional tone, and to also be as respectful as you can, and make sure that you're protecting the client in terms of further representation, right? Because even if you fire a client, you have a duty to that client, and that duty survives the relationship. So if you do decide that you can no longer represent a client, you need to be mindful that you're doing everything that you can to sort of preserve what their interests are going forward. So that means that even if you're angry about something, you can't, obviously you can't share information anyways because it's confidential. But if, for example, if you were getting off record for a client in court, you need to be as spare as possible in that application to get off the record so that you're not potentially damaging a future relationship with a different lawyer. Okay, so in terms of being fired, this is a really painful one, and will likely happen throughout the course of a career for a number of different reasons, right? Sometimes a client will say, you know what, like I came to you first, but my mom called around and her friends, neighbors, whoever is going to take on my file instead, and that's okay. So you have to act with as much grace as you can under these situations. If the client comes to you and says that they are dissatisfied with how it is that the services have been rendered, then I think that it's worth a conversation at that point to understand what it is that their issue is and see if there's any room for that to be rectified. So, you know, if the client says, you know, I just really don't feel like I know what's going on with my file, and you know, I don't feel like I've you know, supported or something like that, then, you know, maybe it was that you went through a busy period and you didn't spend enough time sort of contacting clients to make sure that they have an update or enough information on what's going on in their files. So maybe that's worth a conversation and an explanation and sort of a suggestion that it can be rectified moving forward. And then sometimes it's not. So if you are fired, then you need to make sure that you're, same way if you fired a client, that you're taking steps to ensure that the client is going to be okay moving forward. So, excuse me, that might mean returning documents or you know, closing the file in a way that is going to again preserve their best interests. It will happen sometimes, if you're like me, that sometimes the clients you'll lose touch with. So that can happen for a variety of reasons. Sometimes if somebody is dealing with addictions, then their file may not be at the forefront of what they are paying attention to, and they may fail to keep in contact with you. So I think in that kind of case, you need to make some real efforts to find the client in the best way that you can. Even if you've put it in your retainer agreement that it's up to them to stay in touch with you, you want to make whatever efforts that you can to sort of regain contact with them. And you want to document all of those efforts in case there's a need down the line to kind of show what efforts you've made. So within the criminal context, you know, if I'm, excuse me, telling the court that I've lost touch with a client, they're going to want to know, when was the last time that I had contact with them? How did I have contact with them? Have I sent a registered letter? All of these kinds of things. So it's really important with this kind of stuff, and with everything, frankly, that I've spoken about, that you're taking good notes, that you're docketing your time, so that if ever there is a need to kind of show your work, show, you know, what efforts have been made, that you'll all have them clearly laid out and you won't be at a loss. Obviously, the ideal way to end a relationship is with a very happy client, where you're closing the file. Closing a file is an ideal time to sort of kind of end the relationship on a positive note, make sure that everything has been tied up, and that the client feels that everything has been taken care of. So that means sending a closing letter to the client that indicates what's happened with their file, what the outcome was, finalizing any money or any billing, things like that. And that might be also the time to encourage them, if they feel comfortable, to leave a Google review or some other sort of testimonial that will help for you in the future to sort of advertise or to promote yourself. Okay, so along with ending a relationship, and this is these can be both in sort of the good or the bad ways of ending a relationship. There are certain logistical things that you're going to need to take care of. Okay, so for if a matter is in court, then you want to make sure that you're getting off of the record. And so you may need to write an affidavit that sort of indicates that there's been a breakdown in the solicitor-client relationship and that you're getting off. And that makes sure that you don't have any ongoing obligations to the court. Another thing that I've started doing that I find really helpful is writing letters of disengagement. So this is helpful if you've done an intake, for example, with somebody and they've decided not to hire you. Then you can send them a letter that says, okay, we met, we discussed your file, you have decided that you're not going to pay the retainer fee. This ends our relationship. And so then it's very clear that you're no longer acting for the person, and you're not going to have the person come back to you sort of, a month or 3 months down the road saying, why didn't you do this for me? So again, this comes back to the very clear communication that sets out the expectation and also sort of formalizes what the status of the relationship is so that everyone's on the same page. With closing letters, I think those are also a really excellent opportunity to sort of emphasize what's happened with the file, and then include any information that the client may need going forward. So if there are any steps that they need to take once the file is closed. So in some case, well, in a criminal context, maybe they want to know about applying for a pardon or having their fingerprints destroyed. You can include that kind of information in there. And then it sort of helps to sort of close off that relationship. Okay, so I'm speeding through this a bit faster than I thought, but so the main takeaways here is that the most effective client communication or client management comes when there's a solid foundation of communication that involves the client understanding the expectations of you and the expectations of themselves. It also means that you're enforcing boundaries so that you're not sort of burning yourself out or engaging in work that's not sustainable for yourself. You're also maintaining your professionalism throughout these tough conversations and throughout the end of the relationship, should it happen in a way that we were not expecting. And again, I really encourage you to use a retainer agreement as a touchstone in any kind of file, regardless of whether it's really small or whether it's bigger. And you can find precedents for those online. I'm not sure if the Law Society has those, but that's a really important thing. And as with anything, make sure that you get it in writing as much as you can, just so that you have something to go back to should there be any issues. So now I've just talked to you guys for a long time, and so I'm wondering if anyone has any questions. Rebecca, do you have anything that you want to bring up, or Santana?
No, I think you did an amazing presentation. Thank you so much. We'll give it a couple minutes just in case anybody does have questions. But if they don't, please do not hesitate to reach out to myself or Rebecca from the Law Society, as well as Anne Marie herself. We'd be happy to answer any questions that may come up as well.
Okay, we'll give it another minute. Does anyone have anything, any other comments, anything that's sort of been an issue with you? I guess I've answered everything, Rebecca, all possible issues with client management.
Well, yeah, I mean, I really appreciate what you've gone through. Sometimes we don't have questions right away and people reach out afterwards. So thank you again for taking the time and providing your thoughts. Does anybody
I see someone.
Looks like maybe someone does. Okay.
Hi, Marie.
Yeah, hi, thank you. This was really good. No, I just wanted to mention that I don't have a whole lot of questions, but also I'm in-house legal counsel, so it
Okay.
also brings a whole, it's a bit of a different landscape. So
Yeah.
anyways, I just wanted to mention that. And also even for CPD, obviously, we often have different topics, but there in Nunavut, yeah, there are, some in-house legal counsel like in government or
Yeah. Yeah. Yeah.
I'm at NTI, so
Okay.
in any case, yeah, it's a bit different. Let me just put it that
Yeah.
way, but
Yeah,
I
for sure.
appreciate the presentation. Yeah,
Okay.
thanks.
Well, thanks for coming. Okay. Well, I guess if that's it, then we'll leave it there.
That's perfect. Thank you so much again, Emery.
Okay. Thanks for having me.
We really appreciate it from the Law Society. And as Rebecca mentioned at the beginning, we do have other CLE opportunities coming up in the next month. So please feel free to check out the website to see what those are.
Awesome. Thanks again for having me.
Thank you again, Anne Marie. Thanks so much for being here.
Okay. Take care.
Okay, thanks.